Welcome to this rapid-fire explainer. Today, we're unpacking the Ray Epps paradox: defamation, actual malice, and media liability. How does a guy accused on national TV of orchestrating a riot actually lose his defamation case? Well, it comes down to his human story, an incredibly high legal standard, and some massive corporate fallout. Section 1. The January 6th Scapegoat. Okay, let's look at the timeline. January 5th, Epps tells a crowd to enter peacefully. On the 6th, he actually de-escalates things at the barricades. And by summer of 2021, the FBI completely removes his photo from their website. A former Marine and Trump voter, Epps testified he totally believed the 2020 election was stolen. But crucially, he walked away when the violence broke out. The fallout for him was absolutely devastating. Despite just getting a year of probation, severe threats forced him out of his hometown, made him sell his ranch, and relocated him to a tiny RV in the Rockies. Section 2. Anatomy of a Conspiracy. The narrative spread like wildfire, amplified heavily by Tucker Carlson, who claimed Epps was on video encouraging crimes and riots. But look at the contrast here. Fox broadcast claims he was a federal provocateur. Yet, under oath, Epps flat out answered, "No, sir," to working for any federal agency or police. Still, the broadcast kept rolling. They brought on guests like Darren Beatty and Rep. Thomas Massey, suggesting federal agents were secretly encouraging the chaos. Section 3. The Defamation Lawsuit. So Epps fought back. He sued Fox News and Delaware, claiming they ruined his life by using him as a convenient scapegoat. His lawyers argued Fox intentionally spread falsehoods, ignored skepticism from their own staff like producer Abby Grossberg, and totally brushed off Epps's public denials and FBI clearance. But in May 2026, a federal judge dismissed the lawsuit for a second time, citing insufficient evidence of fault. No way, right? This signature right here finalizes that dismissal. And it brilliantly illustrates the turning point, moving away from Epps's personal trauma and relying entirely on strict press rules. Section 4. The Actual Malice Standard. To win, Epps had to prove actual malice. That's a seriously strict legal standard, requiring proof that a publisher knowingly aired false info or acted with reckless disregard for the truth. Why did the suit fail? The judge noted Carlson actually disclosed the underlying facts. Internal staff doubts didn't directly reach the host, and given the chaotic context, the claims weren't deemed objectively implausible. Basically, having an improper motive or relying on a controversial source just isn't enough to prove actual malice. The courts keep this bar extremely high to protect the First Amendment. Section 5. The Corporate Fox Effect. Now, let's zoom out to Caremark claims. These are massive shareholder lawsuits aiming to hold corporate boards accountable for totally failing their basic oversight duties. Plaintiffs pointed to a pattern of red flags, connecting past retractions like the Seth Rich scandal right to the ignored warnings about Dominion voting. And that specific failure to monitor broadcast claims, it resulted in Fox settling for a staggering $787.5 million. Literally massive. This is a real game changer. Media companies are terrified of boardroom liability now and are increasingly settling to avoid risk, like Paramount's recent $16 million settlement with Donald Trump. So what does this all mean? Will the incredibly high bar of actual malice protect free speech, or will the looming threats of massive shareholder lawsuits ultimately chill journalistic freedom anyway? Thanks for joining this explainer.